Okay, welcome. So this review is going to be regarding chapters 4, 5, and 7. We're going to start out with alternative dispute resolution, and then we're going to continue with chapter 5 and then chapter 7 as well. So let's begin with alternative dispute resolution, okay? Perfect. Someone wants to join. Okay. She should be able to join now. Okay, perfect. Hello, Jasmine. Okay, perfect. So we're going to start with chapter 4. This is regarding arbitration. So a lot of companies, what they'll do, so going into a court of law can be very costly and time consuming. It's also stressful for both parties, the plaintiff and the defendant, especially in a commercial case. So what some companies will do is they will go to alternative dispute resolution, whether that be a civil case versus an employee, or they will do that in another company in a contract. And sometimes they can do a binding agreement or a submission agreement, which we'll get into later into this chapter. But alternate dispute resolution is typically faster and less formal than a court of law. So a lot of companies, before bringing it to a judge in a court, will use alternative dispute resolution to minimize costs and to be able to have less time used in order to solve an issue between two firms. So let's scroll down here. The first type and the most lenient form of ADR is called negotiation. So all this is, it's two of the parties. Let's say we have a business called Wallet Manufacturers, Inc., and Fob Manufacturers, LLC. Let's say that Fob Manufacturers used, let's say they agreed to, let's say the wallet company decided to loan money to the Fob company, and in the contract they stated if they're 35 days delinquent, that they if there's a legal problem, that they would have to they would start out with negotiation. So the Fob company, that is the debtor from the wallet company, they could try to negotiate. So the owner of that company, the owner of the company that gave out the loan, and then their lawyers can try to work out a different loan term. Maybe they extend the payment time. They're going to go to negotiation that way. They somewhat settle the case. Give me 1 second here. Someone's trying to join. Okay, perfect. Okay. And so in negotiation, we typically have two types of the negotiation. So in adversarial, think of this as adversity. It means that it's something hard. It means that two parties don't necessarily agree with one another. So in adversarial negotiation, the two parties don't care about each other. They're just trying to get the most out of it for themselves. So what some companies will do is there's also going to be problem-solving negotiations. So that means the two firms say, look, we want to get our money, but you can't afford to pay us. Let's try to work out an arrangement where we both have joint gain. How about we extend the loan term, right? Therefore, we get more interest on top of our principal, but you don't have to pay for the next month. So let's say they decide to extend the term of the loan by a year. Let's say they did a 5-year note and say, okay, we want to increase it to 6. So the good thing for the defendant, which is the Fob company that's delinquent on their loan, is that they get an extra month to be able to make the payment. And the benefit for the lender, which is the wallet company, is that they get an extra year term on the loan, which means they can make more in interest to recover their loss. So if they want to do that, that would be part of the problem-solving negotiation. Okay. So the second stage, let's say negotiation doesn't work out, mediation will occur. So this happens. So the parties are going to select a neutral party, typically a mediator, to take a look at the facts and help them work together to resolve the dispute. So the mediator is going to take a look at the case, see what's going on, and then each party is going to write a brief explaining why they should win. So let's say, for example, we're not able to agree on our debt case. Let's say we had a breach of contract where we weren't able to pay the loan back. Um, let's say we needed to hire a mediator in order to settle the dispute. That way we don't have to take it to court. So what we would do is we would we would have the mediator review the facts, and the reason why it's good for us to have a mediator is that way us and the company that lent us the money can still maintain a working relationship in the future. So that's a benefit to mediation. It doesn't really affect the relationship. Think of it almost like a marriage counselor with a couple. The couple has a bad argument, or they're having turmoil in their marriage, and the counselor is a third party that's unbiased that will help them resolve their issues. That is essentially what mediation is. So the mediator can also help come up with more creative solutions from an unbiased standpoint between the two firms. So companies will do this to maintain their relationship and get an unbiased opinion on the dispute. Okay. So if mediation does not work out, we can go to what's called arbitration. So arbitration is very formal. Um, so for example, like we keep scrolling down. So an arbitrator will be selected for a particular case, right? So both parties are going to present their case to a neutral third party, just like mediation. However, the parties can introduce witnesses and documentation, and they can cross-examine the witnesses as well. And the fact finder can make a legally binding decision. In mediation, they can't do that. They can't get to a legally binding decision. So that's one of the differences. So a trial and arbitration hearing are going to be similar. But the difference between a trial and arbitration is that the arbitrator is going to take more of an active role in the hearing. So the arbitrator is more likely than a judge to question a witness. And also, you can go online and you can see court records from trials. An arbitration hearing is not required to be in public record. So some people might do that in order to guard their reputation too. So arbitration is more formal than mediation, and they can also produce a legally binding decision. And also, the arbitration typically is a lot faster than a trial. Trials can take months or years. Arbitrators typically can provide a decision within 30 days of the hearing. Okay. So that we also have an arbitration award. So it can be set aside for 4 reasons. An arbitration award resulted from fraud or corruption. The arbitrator was biased or corrupt. The arbitrator misbehaved in a way that prejudiced the rights of a party, and the arbitrator misused the arbitrator's authority of making of the award. So let's take a look. So the arbitrator, right, the decision that they make in this award. So no monetary compensation is going to be awarded. So let's say, for example, the arbitrator was biased in favor of the defendant. The decision, the arbitration award, can be set aside if, let's say, for example, the judge was a friend of the owner of the fob company, the defendant, who is delinquent on the promissory note. That could set aside the arbitration award based on one of those 4 criteria. Okay. We also have a binding arbitration clause. So let's say let's do a different example. Let's say I have an iPhone here, and then let's say I manufacture iPhones. I'm Apple, and I sign a contract with a semiconductor company to be able to supply our manufacturing plant with 10,000 semiconductors a month for the next 12 months, right? Now, in that clause, let's say we have an issue. Let's say the semiconductors don't work. Let's say they simply don't have the money for inventory, and they can't provide us with what the contract says. In the contract, we can put in a binding arbitration clause. So basically, all this is say, hey, if we have any type of legal issue in this case, or any type of dispute, we have to go to arbitration no matter what. That's why it's called binding. Binding means it sticks in. It means we have to do it. So that would be an example of a binding arbitration clause. Now, let's say, for example, let me just make sure that we're sharing our screen. Good. Okay. Just give me 1 second here. I just got to check some. Okay. Who's in here? 1, 2, 3, 4, 5, 6, 7, 8. Okay. Perfect. Okay. Okay, good. All right. And I just want to make sure we're recording one more time. Good. Okay. All right. Perfect. Just want to make sure. Okay. Let's continue. So if a contract doesn't contain a binding arbitration clause, in the contract, we can say, hey, let's say, for example, if you don't pay us, we don't have to go to arbitration. But if you're not able to supply us with the semiconductors, then we can enter in what's called a submission agreement, meaning, okay, we don't have to go to arbitration for this particular legal issue, but we can go for this one. So binding is overlapping, means we have to go to arbitration for any dispute that occurs. A submission agreement means that for a specific dispute, we have to resolve it through arbitration. Okay. Okay, then we also have, keep scrolling down. We also have MedArb. So that means if, let's say we start out in mediation with the semiconductors and Apple, right? So we can agree to start out in mediation. And let's say we do agree upon a few points. Let's say the payment's fine. That's not a big deal. We can extend it. Let's say the quality's okay. But let's say we have a issue regarding the number of semiconductors that are coming in, we can take that issue in particular to arbitration. So the third party that we hire, whether it be the mediator or arbitrator, since they know some of the facts, they could participate in both the mediation and arbitration. So because of that, the MedArb will be able to conduct that. Now, there is a problem with MedArb because if we bring in the same person for mediation to arbitration, the third party may no longer be neutral because they've understood and seen the facts of the case. So because of that, it's raised an issue in the world of law. We also have a summary jury trial. So think of this almost as like a mock trial. It's a little different though, and I'll get into it. So basically, it's a non-binding jury verdict. So it basically simulates what would happen if it was taken to a court of law. The good thing about a summary jury trial is that it's very quick. It only takes a day, and it's way less costly. The main reason why people do it is because it's so fast, and you get a verdict and see how the case is going to be viewed before a jury of peers. So that's why people do this, just to see if it's even worth it taking it to the court or not. Now, if it's not settled for whatever reason, let's say the defendant loses the case, the plaintiff wins, but the defendant believes that there could be evidence to support their side, they can go ahead and advance it to a regular trial in a court of law. Okay. So we also have a mini trial. So this is going to be similar to arbitration mediation because it also involves a neutral third party. So business representatives are going to be there. The lawyers are going to be there. The main reason why people will do a mini trial is that it's going to cost less than arbitration. That's a big thing that you're going to see with these alternative dispute resolutions, is that it takes a lot less cost and a lot less time than a normal trial. Also, in this mini trial, the business representatives understand the complex matters of the dispute. And then the third reason is that the procedures in the mini trial are going to be modified to meet more precisely the needs of the parties. So let's say, for example, we are still in that semiconductor case and we decide to do a mini trial. That way we can show, hey, this is what happened. This is what happened. And then we can give that over to the third party, right? That way we are more focused and we have a little more specific attention for our issue. That way it gets resolved. And it's also going to cost us less money too. So we also have a private trial. So this is a little different. So in a private trial, you're going to select a referee. So the disputing parties will pay a referee to legally binding judgment in a dispute. Okay. Oh, sorry on that. Okay. So the referees don't have to have specific training. A lot of retired judges do this and they become a referee. So a lot of this will happen in a business situation is where it would be most common for a private trial. So let's say, for example, we go back to Apple and the semiconductor case, right? The referee is going to write a report stating the findings of fact and the conclusions of law, and then the report will be filed with a trial judge. Okay. Okay, so keep going down. Okay, so that is all the key terms for chapter 4. The main things you guys need to know is mediation, negotiation, arbitration, and negotiation. Those 4 are going to be very key. All right, so that's chapter 4 wrapped up. Let's go ahead and advance on to chapter 5. So this is going to be constitutional principles. Okay. So when the Constitution was created in America, the Constitution established a system of government called federalism. So this allowed the authority to govern to be divided between the federal and state governments. The reason why this was done is so that the federal government didn't have too much power over the states in a court of law. So that was one of the reasons why federalism was established. All right. And also, we have in the Constitution, you guys probably remember, we have checks and balances. So we have 3 branches. We have the legislative branch, which makes the laws, the judicial branch, which reviews the laws, and then we have the executive branch, which carries out the laws. So each one of them regulate one another. So, for example, the legislative branch, they can veto a president wanting to pass a bill. The Supreme Court, let's say Congress passes a law that's unconstitutional. The Supreme Court can use judicial review, which we'll go over later, to declare that law unconstitutional. Okay. So we see here judicial review. It means that the courts can. So early common law will establish judicial review. So it allows a court to review the constitutionality of lower courts' decisions as well. So it's not just for the legislative branch, but let's say for example, a state passes a law that bans talking bad about a certain politician. Well, the Supreme Court can use judicial review to declare that law unconstitutional due to the supremacy clause, which we're about to get into. So the supremacy clause means that the United States Supreme Court is the lay of the land, meaning that they have authority over the lower courts to declare certain laws unconstitutional. So this means that, let's say we have state and federal law. The federal law is going to always be over the state law due to the supremacy clause. That way, the states don't have too much power over the government. Okay. And then we also have concurrent authority. So all this is, the government has the power to regulate the same subject matter. So let's say, for example, right? Let's say the government establishes certain environmental standards. Let's say for a warehouse or an oil and gas company in California. Okay, the oil and gas has to meet this certain criteria in order to be within our environmental laws. California, as long as it's constitutional, they can also insert additional laws to regulate the environment. This is very common in certain states. California is doing it now with a lot of the farms there. They're putting on harsher environmental regulations relating to greenhouse gases. And as long as those are constitutional, there can be concurrent authority. So not only do the farmers have to follow the federal law, they also have to follow the California state law as well. Now, let's say that, for example, the California state law is unconstitutional. Let's say that California sets a law that the farmers are not allowed to speak out against, let's say they're not allowed to speak out against the environmental law. So the Supreme Court and the United States federal courts can unleash what's called federal preemption. So they can overrule the state law as well. And it's also known as field preemption. Okay. And then in the Constitution, we also have a clause called the Commerce Clause. So all this is, it means the United States government has the right to regulate commerce with foreign nations amongst the states. So this basically, it allows the government to be able to regulate interstate commerce. Okay, scroll down. Keep going. So we also have a term called police power. So all this is, the state is able to enact certain laws that will safeguard the health and welfare of the citizenry. So the state, for example, they can have their own criminal laws, building codes, zoning laws, and sanitation standards for restaurants and regulation for the practice of medicine. So let's say, for example, you guys live in a gated community. It's pretty common here in South Florida. Now, in the gated community, each house that is built, the houses are zoned, therefore they're allowed to be built there. It's called residential zoning, right? Now, I can't go in there and start a company, knock a house down, and then put a fast food restaurant there. That's because that's going to harm the welfare of the citizenry, because it's going to create a lot of traffic, it's going to create a lot of noise, and also the garbage there might create an abhorrent smell, right? And that's because we have certain zoning laws that will prevent us from putting big places of business in residential areas. So that's why zoning laws exist. In addition to that, we'll also have sanitation standards for restaurants. That way people don't get sick. So the state will have certain health codes that restaurants have to follow in order to make sure the citizenry does not get sick or ill. So that's what police power is. It allows each state to safeguard the health and welfare of its citizenry to the best of their ability. So we also have what's called a dormant commerce clause. So if a law substantially interferes with interstate commerce, it's going to be unconstitutional. So let's say, for example, the United States sets a law stating that Ohio and Michigan can't trade oil with one another. Now that's going to significantly interfere interstate commerce. So that law is going to be declared unconstitutional. So that would fall under the dormant commerce clause. And let's say the state, for example, wanted to prevent Kentucky from trading timber with Minnesota, right? So the commerce clause would be in effect there because the state is trying to pass a law that affects interstate commerce significantly. Okay, let's keep going. So we also have the Privileges and Immunities Clause. So all this means is that states cannot discriminate against citizens of other states regarding to ordinary and essential activities. So for example, let's say I'm a Florida resident and I want to buy a property over in Tennessee. Let's say I want to buy an industrial warehouse for my construction business that is based in Florida. The seller of the property in Tennessee can't say, hey, I'm not going to sell you this property because you live in Florida, because that would be against the Privileges and Immunities Clause. So all it does, it just prohibits states from discriminating against citizens of other states engaging in ordinary and essential activities. So let's say another example, let's say for my construction company, someone wants to apply from North Carolina. I can't deny them just because they're from North Carolina. That would be a violation of the Privileges and Immunities Clause. I can deny them for another reason. It would be too hard to travel, communication would be hard, etc. But I can't do it just because of the state that they're from. So we also have a clause called the Full Faith and Credit Clause. So all this is, it means that judgments in a court of law in another state must uphold in another. So let's say, for example, in the state of Michigan, someone puts a judgment, a lien on my house. Let's say I'm delinquent on my property taxes, right? Let's say I move over to Georgia. that judgment is still going to be valid in the state of Georgia, even though it's in another state. So that is where the full faith and credit clause occurs. So we could also have, let's say, for example, I live in California and I have a will, right? And I die, and all my children are the beneficiaries of my will. They live in Colorado. My will will still be upheld in the state of Colorado because of the full faith and credit clause. And then we also have the contract clause. So that means the United States government, they cannot pass a law that's going to impair an obligation of a contract. So here, the United States passed a bill regarding mortgages, right? So there was an example. Let's say the United States passes a law saying if anyone is 50 days delinquent, the minimum amount of days to be delinquent on a mortgage before the property can be foreclosed is 50 days. Let's say 4 years ago, let's say I'm delinquent 35 days on my mortgage, right? And the bank says if you don't pay after 35 days or less, we have every right to foreclose on your home, right? So that would be in violation of the contract clause because that U.S. law is going to contradict the contract that I signed with the lender regarding my mortgage. So that would be an example of the contract clause being in place. Okay. So we also have political speech. So that's just speech supporting political candidates or referenda. This particular part of the First Amendment is going to apply to corporations and companies. So at one point in the United States history, firms' political advertising was banned because they feared that corporations with large assets could drown out other voices. However, all this does, it means that corporations technically have the same free speech right as individuals. So corporations can endorse a candidate based upon this clause in the First Amendment, political speech. So we also have commercial speech. All commercial speeches, it's basically just advertising. It's speech that's going to convey information related to the sale of goods and services. So let's say, for example, I want to sell lawnmowers and I announce in a newspaper that I'm selling lawnmowers. That would be an example of commercial speech. Now, let's say I said my lawnmowers can cure cancer. Well, that commercial speech is going to be misleading because a lawnmower will never cure cancer. So that would not be protected under the First Amendment because it's misleading. And you'll see in this chart here, that's exactly the case. So we also saw, so let's take a look at Bad Frog Brewery versus New York Liquor Authority. So I'll give an example. Let's say we have an alcohol company. Let's say Coors Light makes an advertisement saying this beer is going to get you drunk up to the clouds, right? And say drink till you can't, or let's say Bud Light says drink until you can't no more. And some guy buys a Bud Light, he drinks it after seeing that ad. He goes out on the road and he drunk drives and he kills 2 people, right? The family, the victim, can sue Coors Light for saying, hey, this advertisement caused this guy to buy a beer, and you said that he could drink until he couldn't no more, which made him drunk, and he killed 2 people in our family or our friend, right? It would usually be the family of the victim, right? So that would be an example of that speech possibly not being protected by the First Amendment, and the plaintiff in that case might be able to win. Okay. So the First Amendment's not going to protect defamation, and we'll go over more in depth what defamation is. All defamation is, it's speech that's going to harm the reputation of another person. So let's say, for example, I go, I don't know, let's say who's in here. Hold on. Let's say, for example, I say Andres. Let's say, for example, I say Andres is a horrible student. let's say I say Andres cheated on his last exam. That's going to be an example of defamation because that's going to harm his reputation. Okay, so defamation is going to be explained more later in the chapter. Let's get into the establishment clause. So all the establishment clauses means that the government cannot make a law respecting an establishment of religion. So the United States government cannot create a religion in a law. That's all the establishment clause is. So we also have the free exercise clause related to religion. All this means is that the government cannot pass a law stating that this religion cannot be practiced. So the government can't pass a law banning Judaism or banning Islam, right? Because the government has to remain neutral in matters of religion, regardless of what happens. So this happened in 1966, for example. So an employee of the California Department of Education named Tucker would sign his memos with SOTLJC, which means Servant of the Lord Jesus Christ. However, the California Department of Education wanted him to stop because it might cause some commotion in the workplace. So Tucker sued regarding religious symbols in the workplace. The corporation, the education company, give me 1 second here. Who wants to join my call? Hold on. Wait a minute. Just trying to get him in here. There we go. There we go. Okay, perfect. Let's continue. Okay, so because of that, the corporation violated the free exercise clause because they prevented him from expressing his religion. That's not allowed in the Constitution. So therefore, Tucker won the case. So let's get more into the Fourth Amendment, which is just freedom from unreasonable search and seizure. So someone can't just go in your home saying, hey, you have cocaine in your house. We're going to go search your home. They need to have a proper search warrant from a court stating that law enforcement agents can go and search and seize items specifically described in the warrant. So you can't just go in someone's house on the suspicion that they have drugs in there. You need to get a warrant from a judge, and you have to state specifically what you're going to be looking for. It could be computers, that could be documents, that could be anything of that nature. Okay. Going down. We also have due process clause. So this entitles everybody to a fair trial, meaning that no one can be deprived of life, liberty, or property. So no one can have their home foreclosed. No one can go to prison without due process. So that goes into procedural due process, which means that the government has to have a fair trial, fair procedure in order to take life, liberty, or property from an individual corporation. There must be a reason to do it, and they must go through a legal process. And then we also have substantive due process. So all this is the basic fairness of laws that might deprive an individual of life, liberty, or property. So this means that when a law is passed, there has to be a good reason why, if a person violates them, that their liberty or property should be not allowed to be used. So I can't say, hey, this person can't use their property because they're 6 feet tall. We can't do that because that's unfair. Why would you punish someone for being 6 feet tall? So we can't do that. That's going to violate substantive due process. So we also have the takings clause. So let's say, for example, let's say a government wants to take a private property for public use. Let's say go back to a warehouse, let's say, or better yet, let's say we own an office building. Let's say we own an office building in Philadelphia, a 30-story high rise, and the government wants to put a museum on the first floor. So the government is going to have to pay us a fair market value for the property. So let's say they want to buy the building for $28 million. So the government's going to have to pay us, our company that owns it, $28 million for the property. Okay. We also have what's called the equal protection clause. So regardless of someone's class, or social standing, everyone is protected equally by the law. So Elon Musk and the homeless guy you saw on the street yesterday are going to be protected equally under the law due to the Equal Protection Clause. So let's say, for example, we have a law that prevents someone from exercising a fundamental right. Let's say, for example, I don't know. Let's say someone is not able to exercise their right of assembly. Let's say in Texas they ban students from protesting at or in a specific area. Let's say you're not allowed to protest in downtown during rush hour. That action could be subjected to strict scrutiny because that prevents the students from exercising a fundamental right as listed in the Constitution. And we also have intermediate scrutiny. So this is based on gender legitimacy of children. Okay, so we're going to do chapter 7. We're going to get through it as much as possible. Okay, so let's keep going. Chapter 6 is not going to be on the exam, by the way. Okay, perfect. So we have two parts in elements of a crime. We have actus reus, which is translated roughly to wrongful behavior. So that's going to be a guilty act based on the law. And we also have what's called mens rea, which means a wrongful state of mind or a guilty mind. So the guilty act means someone did something that was against the law. A guilty mind says that they intended to do it. So let's say, for example, I crashed my car because I was angry at my girlfriend, for example, right? That's going to be actus reus. I crashed my car, and let's say I ran away from the scene. Let's say I left her in there. I hope this never happens, but let's say it happens because this does happen in society. So that would be a guilty act, and we also did it purposely. So that's going to be a guilty mind as well, mens rea. So let's say I was driving, right? And let's say I swerved because someone was driving on the wrong side of the road and I crashed the car and I caused my girlfriend to have a broken arm. So that's going to be liability without fault. So let's say when I did this, instead of staying there, calling the police, I drove her straight to the hospital. So that's going to be liability without fault, meaning I wasn't at fault for the accident, but because I didn't stay there, I'm still going to have actus reus. So it's still a guilty act, but it's not going to be mens rea. I didn't have a guilty mind when I did it. I didn't intend to do it. I had to do it out of safety for myself and my girlfriend. So that would be an example of liability without fault. That could also happen. Let's say, for example, a liquor store sells liquor to a 20-year-old and they didn't know they were 20 years old. Now, the shop probably should have ID'd them, but let's say the person presented a fake ID card and they got liquor. They did do a guilty act. The liquor store did have actus reus, but they did not have a guilty mind, mens rea, because they didn't know they were deceived. They didn't know that the person who presented an ID card over 21 was actually 20. So we have 3 different types of classification of crimes. We have felonies. These are serious crimes, robbery, wire fraud, mail fraud, crimes that are really serious that you can either get over a year in prison for or even death. Misdemeanors that can be disorderly conduct. That can be actually not really disorderly conduct. That can be driving with a suspended license. That can be trying to think what else. That could be trespassing. It could be petty larceny. So a misdemeanor is going to be a less serious crime that can either be punishable by fines or imprisonment for less than a year. And you have petty offenses such as violating a building code. That is typically punishable by jail sentence of less than 6 months or a small fine. And so then we have robbery. So you guys have probably heard this between robbery, burglary, and larceny. So robbery means the difference between robbery with burglary and larceny and theft. Robbery means you threaten the person with some type of threat. So if I go over to Renette and say, Renette, I'm gonna punch you in the face if you don't give me $100. and let's say I take the $100 from her because she's afraid that she's going to get punched in the face. That's going to fall under robbery. So let's say I punch you in the face and take your wallet. That's going to be robbery. That's a felony. Now, let's say I pickpocketed you, right? So let's say you're walking in the subway in New York City and I go and pickpocket you. That's going to be theft. I didn't threaten you, but I still took your property. So we also have burglary. So burglary means that we unlawfully enter a building with an intent to commit a felony. So let's say I go inside a bank and my intent is to rob the bank, but let's say I chicken out. Let's say I decide. So let's say I decide to rob a bank, right? But I decide not to do it the last second. That's still burglary because I went into the place with an intent to commit a felony. So let's say I decide to rob the bank and I threaten, say, everyone get on the ground or else, and if you don't let me in, I'm going to start shooting the hostages. So that would be robbery and burglary. So I would get 2 charges of that. So then we also have larceny. So larceny is very similar to theft. So that's going to be the secretive and wrongful taking and carrying away of personal property with the intent to permanently deprive the rightful owner of its use or possession. However, larceny, the difference between larceny and robbery is that I'm not threatening the person with any harm. I'm taking it without them knowing permanently. So there's a difference between larceny and petty larceny. So grand larceny means that every state's different, but it means you typically steal a higher value of items. So if I stole $10,000 worth of inventory from Walmart compared to a candy bar from 7-Eleven, that's going to be the difference between grand larceny and petty larceny. And then we also have arson. So let's say, for example, I'm mad at the guy who crashed my car, right? Let's say I go to his house and I burn down his house because I'm mad. That's going to be arson. So it's the intentional burning of another person's dwelling. That could also be if I blew up his house. So let's say I put a pipe bomb in his house and it caused damage to his garage. I could still be charged with arson. So then we also have white collar crime. So have you guys ever watched the movie Wolf of Wall Street with Leonardo DiCaprio? So that movie is a good depiction of what white collar crime is. So for example, Stratton Oakmont with Jordan Belfort, what they did was they did what's called securities fraud. So they would basically they would cold call people, say, hey, this stock is going to grow a lot. So they would buy the stock and then they would generate hype for the stock and have a bunch of people buy it. This would result in the stock going up. Then Stratton Oakmont, once the stock reached the price that they believed it would be highest at, they would sell the stock and the stock price would plummet because so many shares were out. This was not allowed and is known as securities fraud. So that would be an example of white collar crime. Some other forms of white collar crime are mail fraud, bribery. They'll explain later what it is. It's just bribing a government official or someone that's not a fee for your services to influence them to do a certain action. So another example of white collar crime would be Bernie Madoff's Ponzi scheme. So he told people, hey, invest your money with me and you can get a great return. And what Madoff did was he created phony financial documents and phony account documents stating that people were making money with investing with Madoff. The truth was Madoff was taking the money and using it to fuel his lifestyle. And then the money that he had gotten from investors, he would use that to pay off new investors. So that's what's called a Ponzi scheme. Very common, unfortunately, in society in particular. Now, with cryptocurrency, a lot of people will do the same thing. They'll put it into a crypto fund, and then because crypto is unregulated, it's on the blockchain. The owners of the Ponzi scheme can basically take the money pretty much undetected. It's very difficult. So Ponzi schemes, even though a lot of trading is done online without any brokers, Ponzi schemes still exist with investment funds, unfortunately. So bribery, I just went over what it was, but it's offering a sum of money or even rather soliciting to give money to somebody in exchange to influence them. So let's say, for example, I bribe Joe Biden $80 million to drop out of the election. Let's say I don't even give him the 80 million. Let's say he doesn't take it, but I solicited for him. Even if I solicited to President Biden to drop out of the race, that is still under bribery. So that would be an example of bribery. So we also have extortion. So extortion, it doesn't happen as much. It can be known as blackmail. Let's say, for example, we have a Mexican drug cartel, right? This happens a lot, unfortunately. And there's a small business, and they say, hey, you have to pay us $1,000 a month, or we're going to go and smash your windows. That would be an example of extortion. So they'll say, hey, if you don't pay us this money, we're going to go and cause damage to your business. So that would be an example of extortion. So we also have fraud. So fraud, there are many different types of fraud. You have wire fraud, you have securities fraud, but fraud in general means you sell someone something, or you provide something that's misleading to gain advantage over another person. So let's say, for example, I say, hey, this investment will increase your profits by 25%. Let's say it only increases, let's say it doesn't, let's say you lose all your money. Let's say I pocket the money. That would fall, and let's say you wired me the money. That would be an example of wire fraud, meaning that I was what's the word that I'm looking for? It means that I was deceitful in my actions, saying, hey, this is going to do this, when in reality it did that. And I knowingly knew that it wasn't going to provide you the return. That would be an example of wire fraud. Okay. So we also have what's called insider trading. So let's say, for example, and let's say I'm the CEO of ExxonMobil, and we make a decision, a strategic acquisition that's going to allow us to bump up our stock price. I can't go with that information that the public doesn't know and buy ExxonMobil stock and then sell it. That's going to be insider trading. This could also occur. Let's say I tell my friend Sally, hey, Sally, we just did this acquisition. Our stock's going to go up. Go and buy it. If Sally buys it, she's also going to be committing the crime of insider trading too. So because of that's an example of insider trading. It's getting information from an insider, and that's not available to the public, and buying a security with it in hopes that you can enrich yourself. So we also have false pretenses. So that means obtaining a property belonging to another through materially false representations of an existing fact. So let's say, for example, Jim says, like, and this is a good example here. Let's say he sells vacuum cleaners, and he goes, oh yeah, but as soon as we get the vacuum cleaner, you can pay for a delivery in 3 to 5 business days. Or let's say, for example, we say, hey, to sell your timeshare, just give us $2,000 in closing costs and we'll sell it for you. That would be false pretenses, because we don't actually have someone to sell a timeshare for. Rather, there's a false pretense. So we would be convicted of, well, we would be accused of that fraud, because we're saying, hey, we'll do this for you, even though we don't even have it. So that's false pretenses. We also have forgery. So let's say, for example, Andres. Let's say, Andres, you get your pay stub for your job and you want to write a check to your mom. Let's say you want to get her a Christmas present. And let's say I forge your signature, to, instead of give your mom the money, you deposit it to my account. I use it to buy, let's say I want to buy a new pair of shoes, and I sign your name on a check to go to my account. That's going to be forgery. It means you're altering or writing in a way that's going to change the legal rights and liabilities of another. So if I sign my colleague's name on a check that I make out to a roommate, that's going to be forgery. Okay. We also have embezzlement. So let's say, for example, I'm a trust attorney, right? And I manage your trust for you. Let's say let's say you put 30,000 a month in your trust fund account, right? Let's say you have a trust fund for your kids. Let's say out of that, let's say I take 5,000 a month from that and I use it for my own expenses. That would be embezzlement. So I'm trusted to be able to manage your trust, but I took money from your trust that you deposit and used it for myself. That's going to be embezzlement. And we also have computer crime. So that's crime against computers. Computers be used to commit a crime and involves computers. So let's say, for example, I don't know. Let me think of a good example. Let's say, for example, I'm trying to think. Let's say we have a eBay transaction, right? Let's say we sold an item to someone on the internet and we took the money, we never sent them an item. That could fall under computer crime. And let's say, for example, let's say I am a hacker and I decide to hack into your trading account and take some money in order for me to trade. That considers me a hacker. So I'm going to illegally access a computer system to steal money, which would fall under this definition. And then also we have a cyber terrorist. So let's say, for example, I hack into the FBI's database and I find information regarding classified documents regarding a case. So not only am I a hacker, but I'm also trying to cause a serious impact. So that classifies me as a cyber terrorist. We also have a virus too. So a virus is just a computer program that's going to rearrange, damage, or destroy, replace computer data. I think everyone knows what a virus is. We also have strict liability offenses. So, for example, let's say we I have an example. Renette gave me a really good example yesterday. So Panera Bread, they sold a energy drink. It was, or like a lemonade, I think it was, right? Where there was a higher amount of caffeine than Red Bull and Monster Energy. And someone drank the drink. They had a heart condition and they died because there was too much caffeine in there. The family went to sue Panera Bread. Um, the thing that happened though, Panera Bread did not put a warning sign, a warning label on the drink saying, do not drink if you have a heart condition. So I believe the result of the case, so even though Panera Bread did not intend to kill the girl that drank that lemonade, they're still under liability because they did not provide a warning on the label stating that they could have some health issues. Same with McDonald's as well. So this was actually in the textbook. A lady had spilled McDonald's coffee on her, and she wound up getting third-degree burns and had to go to the hospital. The lady sued McDonald's and won, and now McDonald's and a lot of other restaurants, for hot beverages, they say, this is hot. This beverage is going to be hot. Please drink carefully. It'll say something like that. You've probably seen it. So it will be somewhere on the cup. So McDonald's lost and had to fall under strict liability. So we also have affirmative defenses. So that means somebody can make an excuse for their crime. So they can argue infancy. Let's say, for example, we have a baby. A baby gets into the box of matches and sets the house on fire. We're not going to charge the baby with arson because they're a baby, right? So that would be an affirmative defense for infancy. Let's say we had a mistake of fact. So, for example, let's say the defendant made a mistake that negated the guilty mind. So let's say, for example, they let's say we worked on a car engine and the car engine exploded. We might fall under strict liability, but we could argue in our defense a mistake of fact, meaning, hey, we thought that this item should be here or this particular wiring should be here, and it caused it to blow up. But we did not intend for the engine to blow up. We could also have intoxication. So let's say, for example, I beat up two people at a bar, but let's say someone drugged my drink with GHB. That's also known as liquid ecstasy. So let's say I did that. I could argue involuntary intoxication, stating, hey, this person drugged my drink and this made me act in this way. So let's say I was so in a bad state of mind that I didn't know that the action was wrong. This would be involuntary intoxication. You could also plead insanity. This, you guys have probably seen this before. So people can prove insanity, meaning that they cannot understand the wrongful nature of the act or distinguish between right or wrong. So let's say, for example, we have a serial killer that has mental illness, schizophrenia, depression, everything under the book. They could try to claim insanity, stating that their state of mind, they could not know the difference between right or wrong. This one is extremely controversial as well. We also have the duress defense. So let's say, for example, I go to, let's see, let's say I go to Dylan. I say, Dylan, hey Dylan, if you don't pay me this money, I'm gonna go and hurt your son, right? Let's say I say that, for example, or let's say, hey Dylan, if you don't go and beat up this person, I'm gonna beat up your son, right? So Dylan can testify against me in court, saying, hey, Jared threatened me with harming my son if I didn't go beat up this guy. So that could be in the defense. So let's say Dylan gets charged with battery, right? He could argue the rest defense saying, hey, Jared told me to do this or else he was going to hurt my son. So you could argue the duress defense there. So entrapment means that, so basically, for example, let's say the crime originates with a police officer or another government official who suggested it to the defendant. So let's say, for example, I have a cop stating that, let's say, for example, a cop states, hey, do this, you bribe my guys and you'll be all good to go through this checkpoint. This happens a lot in foreign countries. So let's say, for example, a police officer wants a bribe in order to not pay me a traffic ticket, right? Or for me not to pay the traffic ticket, and he'll pocket the money. I could argue the defense of entrapment, stating, hey, even though I paid a bribe to the police officer, I could argue entrapment. So we also have necessity. So necessity means harm or evil sought to be avoided by such conduct is greater than what is sought to be prevented by law defining the offense charge. So let's say, for example, let's say somebody, I don't know, let's say, for example, someone, we break into a store because there's a gunfight going on, and let's say the store was closed at the time and we broke in. So we might be charged with trespassing, but because the gunfight was more harmful to society as a whole, we could argue our defense trespassing under the necessity defense. And then we also have justifiable use of force. So let's say, for example, someone punches us in the face and we enact in self-defense, punch them in the face back, and we knock them out and cause a concussion for them. We can argue self-defense because we were protecting our life. Okay, let's see if we have more time. We got one more minute. Okay. So in an arrest, so the first thing that will happen is an arrest. So someone, you guys know what an arrest is. They could be a police officer, it could be the FBI, it could be any type of federal bureau that can arrest somebody. So then let's say we create probable cause. So probable cause is going to write out and outline a likelihood that a suspected committed a crime. So let's say, for example, Dylan, you went and you shoplifted $300 worth of an item. And let's say when you dropped the item while the store was looking at you with the tag on it and you left, right, without paying for the item. So in the affidavit, probable cause, it will say Dylan dropped an item at this time with the tag still on it. So that would be an example of probable cause. Okay. So this is all I'm going to be able to go over for chapter 7. Let me see how much is left. Yeah, I'm not going to be able to get done today. Okay. So that is it for chapters 4, 5, and 7. I hope you guys found this very useful. As of right now, I'm offering individual session as well for everybody. So if you guys want to go over chapter 7 or any of the chapters I reviewed today in greater detail, reach out to me and we can do an individual session as well. If you haven't done one with me before, the 1-hour sessions are free and the 90-minute sessions are currently half off. So if you want to take advantage and you're interested, you can go ahead and do that. And if you guys have any other questions for me, feel free to reach out. And this will also be uploaded to YouTube as well. So if any of you guys need to look back at the review today and get some more information, you can do that as well. So that's going to be pretty much it. And I hope this helped everyone.
Much appreciated. Thank you.
No worries. Perfect.
Thanks,
you.
Jared.
No worries,
Thank you.
guys. Perfect. Thank you so much, everyone. Have a great day.
Do.
And the recording will be uploaded in a couple hours. Just a heads up. It takes Google some time to process.